Okay, we're ready to begin the first session of the afternoon. Thanks everybody for being here. This is my first National Whistleblower Assembly as the Executive Director at GAP. I'm B. Edwards, and I became the Executive Director when our previous director left to join the Office of Special Counsel with our first speaker, Carolyn Lerner. I just wanted to say a few things as we begin. One of the speakers this morning, Tony Schaefer, was talking about the idea that in Washington the truth is negotiable, and that is a very chilling idea. And it is a very chilling idea when you think about it, because if the truth is negotiable, then what happens when the negotiations end? What happens is that there is an official truth, which becomes an unquestionable kind of doctrine. And that happens in governments. It can happen. We know, those of us in this community know, that whistleblowers are a very effective way to challenge official truths. Those of us who are a little bit older will remember that it used to be called the big lie. That was the phrase during the Cold War, the idea that if you said something often enough, loudly enough, in enough places, it became accepted as the truth, even if it bore no relationship to the facts. And so there's a long history and tradition of playing fast and loose with the truth. But whistleblowers do challenge official truths, and they are one of our most effective challenges. The people who spoke this morning, I think, made it clear that whistleblowing is dangerous business, and that we need not only the laws that protect whistleblowers, but also enforcement of those laws. And that brings us to our panel this afternoon, because speaking with us this afternoon are those officials here in Washington who are helping to establish credibility and effectiveness in the organizations and agencies that do enforce whistleblower laws. Our first speaker is Carolyn Lerner. She is the special counsel at the Office of Special Counsel. She has been a lifelong civil rights attorney and a specialist in alternative dispute resolution. She's now dedicated to establishing the credibility of the Office of Special Counsel, and it is my pleasure to introduce her.
Thank you very much, Bea. Thank you for including me on your program here today. I'm delighted to be here, and I'm honored to be on this panel with Susan Grundmann and Paul Igasaki. Saturday will be my 100th day as special counsel. And as expected, there is much to be done and a lot to learn. And I know this audience in particular wants to help get me educated. So I'm really glad to be here today. It's no secret that the Office of Special Counsel has been through some tough times. I expect that many of you who are here have some doubts about whether things will be any different with new leadership. So in my brief remarks today, I want to tell you a little bit about my background, the perspective that I bring to the Office of Special Counsel, and then I'm going to share with you some of the actions that we've taken already and goals for my term. Before I was appointed by President Obama, I was, as Bea mentioned, an employment lawyer for 20 years, the last 14 of which I was a partner at the law firm that I helped to found, Heller, Huron, Cherkoff, Lerner, Simon, and Salzman. The firm primarily represents individuals, both federal workers and private sector employees, in employment discrimination and civil rights cases. Before leading my firm, one of my most recent and satisfying cases involved a translator for the Voice of America, the overseas U.S. radio station that the U.S. government runs. The translator was also part of a rock group that made a music video opposing the Iraq War. For this, she was fired. We took the case to court alleging First Amendment violations against the government. And as many of you probably know, cases against the government are tough. Indeed, in our case, the government challenged our right to be in court and tried to get the case dismissed using qualified immunity as their defense. But after years of litigation, the U.S. District Court and then the D.C. Circuit Court of Appeals ruled in our favor. Through working on these types of cases, I am well aware of the effect that government actions can have on individuals, and I'm familiar with the frustrations and limits of litigation. Perhaps as a result, I developed a strong interest in alternative dispute resolution. I've taught mediation at George Washington University Law School. I've been a mediator for the U.S. District Court and the EEOC, and as an advocate, I used mediation frequently when I represented private individuals. It is this problem-solving approach that I bring to the Office of Special Counsel. Before talking about my goals for the agency, I want to introduce the team that will be helping me implement these goals. I asked a number of people who are well known to this community to come join me at the agency, and I am thrilled that they agreed. I want to introduce our Deputy Director, Mark Cohen. Mark, would you stand? As he mentioned, Mark was the Executive Director at GAP before he came to the OSC. Jason Zuckerman, would you stand? Jason is our senior legal counsel, and he was a partner at the law firm of, it's called the Employment Law Group, and he is a well-known expert in whistleblower law. And finally, our Director of Policy and Congressional Affairs, Adam Miles. Adam, would you stand? Adam worked at GAP before he went to the House Oversight Committee, and he was also instrumental, as many of you may know, in drafting the Whistleblower Protection Enhancement Act. I am just delighted that Mark and Jason and Adam are with me. And in our first 3 months at the agency, and it really has only been 3 months, Mark, Jason, and I have been spending a lot of time listening to both the dedicated career staff at the agency and meeting with a wide range of stakeholders. We've heard some terrific suggestions, and we're already taking concrete steps to implement many of them. I want to share with you some of our priorities. As you know, the agency has several important roles, but it has always had a special mandate to protect government whistleblowers. And at a time when our country is in a fiscal crisis, this role has never been more important. There is no question that government workers are in the best position to uncover waste, fraud, and unsafe practices. We recently took a look at our disclosure cases, and over the past 2 years alone, we calculated that whistleblowers who had come to our agency had saved the government about $8 million. This $8 million doesn't even include the savings from disclosures about potential threats to lives, health, and safety that could have resulted in catastrophic losses of lives and money, but for the disclosure. And though these employees perform an important service, studies have shown that about 80% of whistleblowers in the private sector regretted having come forward because of the negative consequences that they suffered. This is also consistent with the experience that we've had at the Office of Special Counsel, where about 80% of our whistleblowers also expressed concerns about retaliation after having come forward. Creating an environment within government where open dialogue about problems is accepted and indeed encouraged is one of my primary goals as special counsel. And though it's only been 3 months, I think we're already making a bit of a change. We've already increased the number of OSC employees who work on whistleblower reprisal complaints. This week, in fact, we're starting the retaliation pilot project at the agency that's going to focus exclusively on retaliation cases. Several attorneys in this project are being detailed from other units of the agency. This commitment of additional resources should reduce the backlog and get relief for whistleblowers more quickly. We must also do a better job communicating. People who come to our agency should feel that they have had a full and fair opportunity to be heard. To that end, we're working with our complaints examining unit to communicate more with complainants from the start of the process. And when a case is referred to the Investigation and Prosecution Division for investigation, we will contact complainants early on in the process and ask for suggestions. Having represented employees, I know how frustrating it is to have to wait for an agency to complete its investigation, especially where an employee is out of work or suffering ongoing retaliation or harassment. One action that we can take is to exercise our authority to seek stays from the MSPB. Indeed, one of my first acts as special counsel was to obtain a stay in the firing of a whistleblower so that we would have an opportunity to investigate the matter before the agency took action against the employee. I also know from experience about the benefits of early mediation. I strongly believe that mediation can help both complainants and agencies obtain quicker and better results. This will also benefit the OSC. Having cases settled will allow us to use our very limited resources to investigate and litigate other cases. So I'm working to expand our capacity and capability to mediate more cases so we can offer this as an option to more complainants at the beginning of an investigation. We're also taking action to make the OSC more accessible. 30 years after it was created, many federal employees are still unaware of this agency. I was amazed when I was nominated for this position how many people would ask me, what is the OSC? They also wanted to ask me, why are you interested in taking this job? But that's another story. I am determined to improve our outreach to federal employees and to make the agency more accessible and well-known. One concrete step that we will take is revamping our website. We want to improve it to make it a better resource for federal employees, both about their rights and to make filing a complaint easier. Recently, both GAP and POGO very generously provided helpful recommendations for improvements to the website. We're grateful for their work on this and hope to implement many of their suggestions. In closing, I want to reiterate to you, my mission at the OSC is to make this public service agency as robust and vibrant as it can be. We will listen, we will be timely, and we will resolve cases with justice. But there is a lot to do, and we know we can't do it alone. So I'm asking you for some things too. Please work with us. Share your thoughts and ideas for how we can move the agency forward together. And finally, please be patient. All of this is going to take some time. Finally, thank you for what you do and what you have done to advance this same larger cause. I look forward to working with all of you.
And our second speaker will be Ms. Susan Grundmann. She is the chair of the Merit Systems Protection Board. Civil liberties and labor rights attorney also. She's also served as the general counsel for the National Federation of Federal Employees. Under Chairman Grundmann, the MSPB provided justice for Teresa Chambers, who is a very important member of our community. Ms. Grundmann.
Thank you, Bea, and Tom Devine and GAP for this gracious opportunity to meet with you and speak to you about our mission, our values, our goals, and our challenges. So let's talk a little bit about MSPB and some changes. Our focus, as you've seen probably the last year, is a little different than the last board. Whereas prior to 2009, the focus had been on national security, and as a result, processing cases much faster, particularly with the legislative reforms in DOD and DHS. Now this board has viewed things a little bit differently, and we view that it is a time to return back to basics and refocusing on those principles upon which we were founded under the Civil Service Reform Act, and of course they are the merit principles, they are the 9 principles that are the foundation of federal employment, they are what makes civil service civil, including, and in particular, the protection from reprisal for whistleblowing. And this principle is important for a number of reasons, because it is the key, as Carolyn mentioned, to good government. Preventing fraud, waste, and abuse, preventing violations of law, rule, and regulation, protecting individuals from a significant and substantial danger to their health and well-being. So we have, first of all, recommitted to these principles in our strategic plan. And our strategic plan is not just to protect the merit principles, but to promote a workforce that is free of prohibited personnel practices, including the protection from reprisal for whistleblowing. This plan was developed in conjunction with our stakeholders, one of which being GAP, and has consistently been a great voice in our community. We recommit to these principles daily through our adjudication functions, our statutory functions. The first being we have issued a number of precedential decisions ordering corrective action for whistleblowers and remanding cases back for a full merits hearing to the AJs. In fact, we issued one last week, King versus Army. In our second statutory mission, which is to issue reports to the President and to the Congress on the health and well-being of the Federal Civil Service, at the end of last year, we issued a whistleblower report wherein we noted that Congress has continually attempted to address these issues, and we urged Congress to be aware of the difficulties that a potential whistleblower would encounter when navigating this particularly difficult area of the law. Now, coming up this year, we will be issuing an additional report, which internally we refer to as Whistleblower number 2. And it highlights a series of best practices that agencies should follow in building an environment where federal employees can come forward without fear of reprisal. Finally, we refocus not just in prevention, but promotion through education of the meaning and the value and the spirit of these principles. As some of you may know, we feature a merit principle every month on our website. This month, coincidentally, it is protection from reprisal for whistleblowing. It's not timing. We also, like Carolyn's agency, embarked on a series of aggressive outreach, not just to employee groups and union groups who understand these types of issues, but to management groups and to good government folks and to affinity groups to educate them as well. Finally, with the advent of social media, we tweet these principles repeatedly throughout the year. And we've added a new gadget, if you will. We have a new mobile app which will allow you to download our cases, our studies, and our other public media wherever you go. But knowledge is power, the power of training and education. But we do have our limitations. And first, in the area of adjudication, we are enforcing the law. We are not writing the law. We are bound by the Whistleblower Protection Act and its letter. And we are also bound by our case precedent from our reviewing court, that being the Federal Circuit. The key case being Huffman versus OPM. And let me get a shout out to my guy here. This is Jim Eisenman. He's our general counsel. He argued Huffman versus OPM. He argued on behalf of Mr. Huffman. Let me mention what Huffman means. It brings to light some of the shortcomings of the Whistleblower Protection Act, primarily 2 of them. That disclosures are not protected if they're made within an employee's chain of command, which is the natural place that an employee would go to with an experience of wrongdoing. You go to your supervisor first. The other area that's highlighted by this case is that disclosures are not protected if they are made within the employee's scope of duties, which is, again, the natural environment where employees would be exposed to wrongdoing. Now, this is different than Chief Judge Igasaki's area of the law, so he's got some other protections that the Whistleblower Protection Act is not advanced. The second area is that while we can educate and promote these merit principles, we don't have the authority unilaterally to change policy, nor do we have the authority unilaterally to change culture, which leads me to this upcoming report, which will urge agencies to create a culture whereby disclosure of wrongdoing is not only okay, but it's actually going to be encouraged. Now, this report finds out that the fear of reprisal and actual reprisal is still there at the same percentage as it was in 1992, which is a little bit daunting because if you think about that, back in 1992, there was no Fear Act yet. So even in the wake of the No Fear Act, people are still experiencing these same types of issues. So what we're going to urge first and foremost is that agencies assure their workforce that management will not be requiring absolute proof of wrongdoing, that a mere reasonable suspicion is going to be enough. Even minor wrongdoing, this is a quote from the report, is still wrongdoing. When individuals bring potential wrongdoing to management's attention, we urge agencies to give that report serious consideration, including referring that report to an impartial individual or office if necessary, like the IG. And even after investigation, if the charges are not verified, management should still tell the employee that the allegation was taken seriously and that the individual did right by coming forward. So this is a lot to look forward to in this report. I commend it to you. It'll be out around Halloween. No time. The timing's not suspect here, but I leave it to you to embrace it and to encourage you to take it forward to support your position. Thank you very much.
Thank you, Susan. And our final speaker is Judge Paul Igasaki. He is the chair of the Department of Labor's Administrative Review Board. Prior to that, he served also as the chairman of the Equal Employment Opportunity Commission, and he's done a great deal to establish the credibility and strengthen our country's protections for corporate whistleblowers.
Thank you, and thank you for inviting me here today. I had the pleasure, as Susan did as well, to appear a year ago when I was relatively new, and I could talk about what our hopes and dreams were, but I didn't have to be necessarily accountable for much at that point. So hopefully what I say today will seem positive after a year and a half on the job. I want to say that our team over at the Administrative Review Board is the most diverse team this team has ever had appointed to it. And Secretary Solis has done a wonderful job at bringing in people from different backgrounds, not just gender and race, but clearly that, but in addition, different backgrounds. We had someone who did civil rights cases at the Department of Justice. We had someone who's come over from City Attorney's Office in Denver, someone from the DC Unemployment Compensation Board, and someone actually who worked in the government accountability area at one point. So we have a number of people on our team who brought a different set of experiences and created a different look to how we're approaching our work overall. I wanted to thank this organization and your allies for giving us input over this past year and a half. We sought, for example, input on coming up with new procedures. We've never had procedures or regulations before. So we drafted a proposal to have regulations in place for us for the first time. Now, I would love to say we're about to implement them, but they're in the bureaucracy somewhere. We finished our input, gotten input from the community. They're being reviewed by the solicitor's office. After that, they go to OMB and the rest of the process, which I'm sure many of you are very familiar with. But I appreciate your help and support in doing that. Over the last year, we've taken our look at our cases, and I don't want to comment too much on what we did because I think our cases speak for themselves. The cases that seem to have attracted the most interest are the Johnson case and Sylvester case, but if people have questions about what we've done, that shows some of the direction and how we're looking at individual cases and applying the law as clearly as we can as Congress intended it to be done. The limits on what you can do as an appellate administrative body are clear. I kind of missed some of the days I had in the EOC when we were actually enforcing the law. I could be a little more aggressive, but at the same time, I wasn't deciding what we get to do to a certain degree as appellate administrative body. Our caseload now, one of the things we wanted to do was cut down the waiting time and get as far down at eliminating a backlog as we could. The term backlog is a politically charged word, so I would say we're trying to reduce the waiting time people have before we can deliver justice. And I think what we've been able to do in this past year, for the first time in a long time, we've eliminated all 3-year and older cases. We winnowed down our 2-year and older cases down to about 14 or so, and we're working on them, bringing them down even further. And that's with 2 less attorneys than we were supposed to be starting with. So, and unfortunately, the Obama administration has been very good at committing resources to this very important area. Unfortunately, the budget process is not producing us those commitments as we would like, but if you have thoughts about that, you might want to share it with your congresspersons. In terms of the kind of cases that come in front of us, all of you know we do a lot of whistleblower club cases. About 80% of the caseload is whistleblower. That's a moving target, so if that's true today, then I would be surprised. It's about that. The kinds of cases that are included in there, because we enforce in 51, 52 different laws, so it's hard to say exactly the mixture of each. The Sarbanes-Oxley cases are a good portion of the whistleblower cases that we get. They've been a substantial part of our caseload, and a lot of the decisions we've made have been focused on that law. We don't know where that's going, because now Dodd-Frank has some new provisions, whistleblower approaches that don't go through us. So does that reduce our caseload in the SOX area? Maybe, maybe not. We're looking at some people are interested after the Sylvester case approaching us more, so we don't know exactly where the numbers will go there. We also get whistleblower cases from the truck safety area. And it used to be that trucking safety cases came up automatically after an original decision by ALJ. That's not true anymore, so the number of trucking cases has gone down considerably, although we still get a decent number of them. When I first started here, they had just passed a new law bringing railroad safety cases to us, and those cases are coming up in volume. So how much they will be, we don't know yet, but there are an increasing number of cases in front of us. They're not in the whistleblower area, but these are all cases that affect our overall caseload. Historically, before whistleblower really took off, ARB dealt mostly with wage and hour Davis-Bacon cases. Those went down considerably, but for some reason recently they've been on the rise. So we see more and more of those. We have a fair number of H-1B immigration cases, occasionally some other immigration-related matters in farm labor and elsewhere. So that's basically what our caseload looks like. We do anticipate we will continue to make progress bringing down our backlog. But one of the things, in addition to the limits on our resources, to bear in mind in terms of speed in handling cases, when you overturn a precedent, it takes a lot more work and time than it takes to just affirm and say, you can't come in. And not that that's how we're pre-deciding the cases, but if we were to go in that direction, it would take more time. And I think it's clear that we've done that more than our predecessor boards, so that has taken some of our time. Beyond that, I think we're very comfortable with what we've been able to accomplish. I very much enjoyed doing this job. I miss the enforcement and public outreach that I would do more at EEOC, but the variety of cases we have here, opportunity to learn new areas of law every single day, and the tremendous support we have from the various organizations, GAP, but unions and other organizations that care very much about protecting their workers, protecting their rights, has made this experience a very positive one. I anticipate over the next year that ARB will accomplish even more. I hope you like what we do, but in any case, I think there will be more surprises as we make more decisions. Thank you.
I think we have only time for one kind of general question that I'd like to ask you, and that is, if you could think either collectively or individually, what are the most important things that we in the whistleblower community can do to support the work that you do, either at the Office of Special Counsel or the Merit Systems Protection Board or ARB?
Well, as I mentioned, you've already started to help us by looking at our website. That's very good, and giving us input. We hope to have an ongoing dialogue with the good government groups. So please keep that dialogue going. I think it's going to be really important to see if we can't get the Whistleblower Protection Enhancement Act moving. I think, you know, as Susan mentioned, we can only enforce the law, we can't change it. And it's very frustrating. And I think I probably speak for all three of us when I say that we know that people are impacted, that we can't help because the law isn't where it needs to be. So I think that would be a pretty high priority. And to echo what Judge Igasaki also mentioned, if you want to happen to talk to any of your representatives about our budget, that wouldn't be altogether bad thing, because we're trying to do a lot with very, very little. And the threat, of course, is that we'll have to do a lot more with a lot less. So that's, I guess, what I would leave you with.
Let me just mention how small our community is. Your next speaker, Bogdan Drakovic, is someone I know from my past. Many, many years ago when I worked for the National Air Traffic Controllers Association, we met him. And in fact, we tried to organize his unit. But because of, there's that term again, national security, they fell out. So this is a very small world. We will meet each other again. But picking up on what Carolyn said, we have often been asked to endorse the new Whistleblower Protection Enhancement Act. I mean, it comes all the time. Because we enforce the law, we have taken no position. But if you desire to expand those protections where you think they should be, then let your voice be heard. We can give you some of the tools. You can get them through some of our courts. You can get them through our decisions, but we can only go so far. So you are our voice. You are our boots on the hill. Do what you need to do.
Well, I'd say ditto to a lot of that. Certainly the budgetary angle and the fact that I think it's very important for your organization, organizations like yours, to be very aggressive on Capitol Hill. We can't do it. You can. Just looking at every law that comes up that really needs a whistleblower component. A lot of them do. The OSHA bill had been up there and was going to have something, but then Congress changed. So just looking at making sure that there's a continuing commitment to whistleblower principles in the law. In addition, one area which I think you are doing, but to keep it up is very important, especially seeing people like Jason join the government is a good thing, but also losing good lawyers on the outside. It's an area where, when I was working in the EEO area, there was a tremendous number of very talented lawyers on both sides of the question out there on EEO. On whistleblower, not so much, defense or plaintiff. And because of that, I think a lot of people who are taking their cases forwards, since we only see it at the appellate level, you can see that mistakes were made at the hearing level where I don't have in front of me what I need to make a good decision in the case. So having lawyers out there who are trained in whistleblower law, who specialize in whistleblower law, is a real important factor. And to the extent you can reach out to the bar associations and through the ties with the firms you already have. It's a little better here in the DC area, but as you move out further west, it's less so. And that's true on the defense side too. I've seen some large regional corporate firms who just don't seem to understand the law either. So maybe that balances out in the end to some degree. But it makes our work harder and limits our options, not having good cases developed at the hearing level. So that's something that I think this organization does well and can do a great service to whistleblower.
Thank you. Just in response to your last remark, I wanted to mention that GAP, and this actually started under Mark Cohen, has begun the American Whistleblower Tour, which will go to campuses, university campuses around the country over the course of the next academic year, meeting with faculty and students in business and law schools in order to start the education of attorneys and corporate managers on whistleblowing and whistleblower protections. Thank you very, very much.